from the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
Welcome to the fourth week in our 8-week series entitled Know the Law. Each week we are dealing with a particular aspect of law that we think will be helpful to you and matters in your life. And on this fourth program, our topic is going to be domestic relations, or often it's called family law. In order to pursue that important topic, we're so pleased to welcome to the program a friend of ours, an attorney in the state of Idaho, Ann Solomon. Ann is with the law firm of Ann Solomon and Sue Flamia, and has practiced for many years here in Coeur d'Alene, Idaho. She holds a baccalaureate degree in the field of economics and political science from Stanford University, and her doctorate in jurisprudence from the University of Idaho. Ann and her partner, Sue Flamia, are well known for their work and expertise in this particular area and practice much in this area. And I should add that our guest has also been very deeply involved with the Conflict Resolution Center in Idaho that's been very successful. It's good to have you on our program again. We've had you here in the past, and
Hello,
thank you for taking time from a busy schedule.
Oh, sure.
Sorry we're behind schedule today, but you've been very gracious with your time.
Nice to be here.
And as always, I'm pleased to have our regular panelist, Janelle Burke, who is also an attorney in the state of Idaho, and she is the law clerk for Judge Gary Heyman of the 1st Judicial District of our state. And I shall invite Janelle to commence the questioning.
And it's a special pleasure to have you here on the show today. And we're going to talk about a very important area because it's a very personal area, that's family law. What do we mean when we say family law?
When I talk about family law, I mean all the things having to do with the structure of families. It means, is there a divorce? It means, is there an adoption, either by a step-parent or a brand new baby being adopted? It means, I include name changes. I have a lot of cases where there are children who want to take the name of a step-parent. So I include all of the issues that involve families.
And this could include happily married spouses who want to draft a community property agreement, or who want to separate some kinds of their properties.
That's a good point. It also includes, it doesn't have to be with a tragedy, you know, that a person goes to an attorney. It can be, for example, I'm buying property and I have some inheritance, and I want the property to be in my name only. And sometimes that involves a separate contract, and sometimes it involves what's called a post-nuptial or after marriage agreement. So there's all kinds of issues involving families.
Now let's suppose, though, that there is a tragedy, or that for some reason the parents, the parties are not getting along. Mm-hmm. At that point, what happens? When does a person need to see an attorney with regard to marriage conflict?
It's a really important question, and it's because the courts are shifting. My opinion over the past 16 years is that the courts are shifting so that they're trying to have less conflict. Okay, so if there's a situation where there's violence, then in Idaho, one of the things is first available to people is they have a restraining order, an automatic type of restraining order available through the courts. No lawyer is involved or need be involved. So that's one thing that people need to know about. That's under the Domestic Violence Protection Act. In that case, I wouldn't wait to see a lawyer. I would just get help, okay? The second type of thing that to me, the law belongs to the people. Okay, I don't think there's anything real exclusive about this mystique of being a lawyer. It's just I love the law and I studied to be a lawyer, but I don't think I have information that's privy. You know, I think there's a county law library that has library books. So one of the things that I stress to people is there are do-it-yourself packages. For example, if you don't have children and it's amicable, it's a well worked out, fair agreement, there are ways to do your own divorce, and that's through a couple of places, at least in Coeur d'Alene, that I'm aware of. But if you don't have that situation, and there are children, and there's kind of complicated property, then I think that's the point at which people need to start to get some legal help.
And certainly if a person is served, they need to consider the implications of the service. Is that correct?
Yeah. In Idaho, once there's a service, meaning someone comes and brings you papers, and there's a summons that says you have 20 days to answer, those 20 days are really important, and you have to determine if, in fact, you need an attorney within that 20 days.
Now, to further set the stage before we go back to Tony, when a divorce occurs, a divorce is actually an umbrella that includes other kinds of things within it. Can you sort of indicate what those aspects or what those particular issues might be in a divorce?
Yes. The first, to me, because I'm a family person and I guess I have a special thing for children, the first thing is the court can determine what will happen with children. We have joint custody in Idaho. That means there's joint physical custody where the children live, and there's joint legal custody, which means who will decide what happens with them. So if there are children, once a divorce is filed, like you're saying, there is an umbrella that entitles the court to go in and say, okay, if a party brings a motion to the court regarding the children, I can rule on where these children are going to live while the action's pending. So that's a real, to me, it's the most important thing. And the other thing, which comes up so often, is what will happen with these debts. There's a house payment, there's a car payment, there's AVCO finance, etc. So the court can look at all the money earned by everybody and look at all the debts and then decide who will pay which debts while this all is settling down. So that's the court's authority. And then the third thing, really important, which you're involved in and Tony mentioned earlier, is the courts now try to direct people into conflict resolution. And some judges here are doing that automatically. They're just funneling them through conflict resolution. Some will do it if I bring a motion or the attorney brings a motion. They'll say, okay, let everybody kind of calm down here unless there's an emergency, and we'll go to a mediator and see if we can get some of these issues worked out. So that's all under the umbrella of the divorce.
And the marriage is a status, and it can be dissolved. But what I hear you saying is that there are these other issues that can be dealt with during the process of the dissolution. Is that a correct way to say it?
Yes.
And would you add anything to that as to the status?
I would not, except that I would just say that it's just the divorce is such a personal issue with the people involved. And my feeling is that as much as they can communicate on the issues, the more long-lasting their agreements will be, and there tends to be less conflict for children. Now, it doesn't always work that that's for everybody's betterment. If there's violence, then it may not work to try to do the peaceful route. You may just have to say, I have to go have a judge tell me what to do. If there's any kind of abuse for children, sexual or physical abuse, my opinion is you get right in and you get the court's help on that.
Let's pursue this on, and I think that was such an important point to make to, for example, protect children through this litigation, because it can go on for a long time, and they need not to be in that insecure situation. But let's now go through a situation where, even though there may have been attempts at arbitration and negotiations, and it hasn't worked, and I would assume that you would be of the position that there are some situations where it absolutely cannot be resolved, and divorce is the only remedy. In that case, and suppose you are representing one of the parties to this divorce, can I take us through some suggestions? I'm thinking of our viewers, of course, and sometimes there's a lot at stake, and a lot of property and a lot of money, and most precious of all, if they're children, the children, and then in one case, one of them may be really quite well off financially, but the other one's going to be without certain resources, and alimony becomes involved. What are some of the things that one should look for and expect from the courts in dealing with the following type things? The physical custody of the children, and when can they see the other parent, or is it divided? What kind of child support and alimony? That's a very general question, but if you could...
But they're really important questions, and they tend to come up all the time with people who, especially people who haven't done this before, and it's such a stressful thing. In Idaho, if a person is about to face a divorce, they should expect joint custody. The only time, in my experience, that that's not going to happen is if there is an unfit parent. Because in Idaho, the statute, 32717B, says that it's presumed that joint custody is for the best of children.
Is that pretty general among other states too?
It's becoming more and more common. Okay.
Now, when you say joint custody, suppose during the time of their school years, K through 12, now, can one expect that one parent would have them most of the time during the school year and the other parent during the summer? I mean, it's not divided equal in blocks of time, is it?
Tony, that is a great question, because my opinion of that is really changing. Mm-hmm. I think when joint custody first became statute in Idaho, that there was a feeling among the courts that they needed to try to do as much splitting of time as possible. But I think that the studies are showing, such as Judith Wallerstein out of Southern California, and some other studies on the effects of divorce on children, is that if you have conflict between parents, joint custody can be potentially disastrous for literally generations, because the conflict prevents the children from trusting and bonding, and they get so immersed in the conflict. So if you have truly loving, harmonious parents, then my feeling is that the courts will try to do a split. And if they're in the same town, in the same school district, even sometimes same neighborhood. I've had people actually split the week, and they're happy, and the children seem, you watch for signs in the children. Do their grades fall? If they're real young, do they regress? Do they act out aggressively with other children? So, and I think once this information gets to the court, then the court decides, okay, maybe this school year will be with one parent, and predominantly summer with the other parent. So joint custody,
especially from the different states and so forth.
And then different states are going to have, now Washington is very good, in my opinion, about advocating parenting plans. They have very detailed plans. When will the child be with each parent?
But if one parent is living in Idaho and the other one's in New York, that even becomes more essential where they are during school time.
Oh, so much, because that ongoing contact that you want to foster with joint custody really becomes impossible. So you're talking about a Christmas vacation visit and a summer visit, and maybe potentially a spring break visit. But joint custody as we know it and try to foresee it isn't possible.
How do you determine in a justifiable way and in a fair way child support, particularly in those cases where both parents have a job at low income, and now that the family's split and at least for a period of time, and that's two households rather than one to maintain, how does the one parent who doesn't have the custody the majority of the time pay their rent and so forth, but yet the child or children have what they need? How does one try to resolve that?
Yeah, well, we have guidelines now, child support guidelines, and they are actually a pretty concrete set of figures wherein you plug in a percentage of the combined income of the parents. So the theory is you don't punish a child by depriving the child of material goods that the child could have at the home of the wealthier parent. So they're really intended to equalize. Some people were shocked when they came out, truly. Because in Idaho, we were used to child support of $100, $150 per month, and in some cases that's appropriate, but in many cases, the child support doubled and even tripled and on up. And so it did shock people for a while, but the judges in this area, Judge Quentin Harden from Boundary County, he helped formulate the guidelines, so we know they represented the whole state. And ironically, as rents go up in this county, the guidelines, in my opinion, are sometimes low. The children don't have enough.
Let's talk about alimony. And again, we've had some progress in the gender question, and particularly for women who, equal pay and so forth. I know there's a lot of problems left yet. But in getting into alimony, now that can also reverse, can it not? That doesn't the court look at the earning power of both parents, and sometimes that may be the woman, sometimes the man that's more highly qualified and placed in position. How do we determine alimony, and which parent, which one of the couple might get that?
Tony, I wondered if you were going to ask me that question, and I was going to try to prepare on that. My general feeling about alimony is that it is not favored. And by that I mean it's just tough as heck to get. It really is. I had one case where the woman was married to a minister, and after 20 years, and she was 55 years old. She had not been working, and she had been in the home with children. And in Idaho, in this court system, I think that the court gave her a little over a year of alimony. And if there ever was an alimony case, I would have thought that was the alimony case. So my general feeling is that it's not favored, that the court would try to maybe give her a little bit more property, or him or her, because it doesn't have to be her, but try to maybe do a property shift instead of alimony. But the factors are, it's under 32705 if any of our audience is looking for it, but the court has to make a finding that one party doesn't have sufficient property or money and is unable to support himself or herself through employment. And then the court goes down through the length of marriage, the income, other financial resources, the health of the parties. So it's a balancing act. And I would say in general, it's really not done in Idaho unless there's real unusual facts.
You trigger my thinking with that answer. It seems to me then that even in the early stages of marriage, and we know many people will be married for 50 years and nothing will happen, but there is also a very high divorce rate, that isn't it very important for both the woman and the man at the very beginning of the marriage to be cognizant of the fact that this could happen down the road in 20 years, and that any preparation they can make, either in education or job experience, may pay dividends, but since the idea of alimony is not as successful as child support.
That is very much true. And I encourage my clients, even though I really support men and women at home, moms and dads at home, if the relationship starts becoming unequal, that I tell my people, you don't even start volunteering, get back out, because after 10, 12, 15 years out of the workforce, especially in this area of northern Idaho where we have a large service industry, making beds and doing things for tourists, it's very hard to support oneself after being out of the workforce.
Janelle Burke.
Following along that line to a certain extent with some short questions, what should a person do if their spouse serves them with divorce papers?
First thing I would do is read them. Okay, don't panic. I would sit down with a cup of coffee or a cup of tea, whatever. Don't panic. Read them, because they may not be as bad as feared. Oftentimes the shock is not in what's in the papers, it's in the tragedy of the divorce. It's like a death. It's like a death of a marriage, and there's all the emotional pain that goes with that. So because I have people bring me papers, and once we sit down and go through the papers, we determine that they're fine. The divorce isn't fine because we don't want the divorce, but what's in the paperwork is acceptable. So then the person just needs to get the advice of the attorney, decide yes if the contents are acceptable, and then maybe the route would be counseling as opposed to. But if the contents are not acceptable, then an attorney at that point would probably be needed to file an answer, and that would need to be within those 20 days.
Can people stay in their own homes during this period of time? What happens?
People are entitled to stay in their own homes. Court orders may be obtained so that people can stay in their homes, particularly people with children. I think that the court is inclined to let them stay in their homes. The court is even inclined to let both parties stay in homes as long as there's no violence or threats, and particularly threats to children.
Under what circumstances would you suggest to people that they might want to consider a prenuptial agreement?
I advocate prenuptial agreements when there is sizable separate property. And by that what I mean is, say for example, I was going to remarry, and it was going to be my second marriage, and I had $50,000 from a house I had from my first marriage. It becomes very complicated if, say, I and my new spouse buy a new home and it gets put in both names, and my $50,000 goes into that home, and then we use some earnings from me and from my spouse, and we make payments, and pretty soon no one can figure out what is the status of this property. But in Idaho, my $50,000, that stays mine. And the only thing that makes it community, because we're a community property state, is interest income that comes from my $50,000. So in those kind of cases, if you want it nice and tidy, which life isn't always nice and tidy, but if you want it nice and tidy, a prenuptial agreement is a good idea, so that everybody's clear as to what will happen when my $50,000 follows me around during the marriage.
Is it possible in a state like Idaho to have common law marriage?
It is possible. We are one of the few states with a remnant from the homesteader days. And I understand there's a bill pending to get rid of common law.
I should interrupt to say that we're doing this show in March and it's pending then. By the time this airs, something will have happened.
It may be passed, but personally, I don't support the bill abolishing common law because I don't think it's that complicated. In Idaho, you have to agree to be married, and you have to tell people or hold yourselves out as being married. Now, some people think, well, that's too complicated, but I look for, do you file a joint tax return? Do you celebrate an anniversary? Do you call each other husband and wife? And do you give each other anniversary cards, for example? And do your friends think you're married? And I don't think it's usually, I haven't really had very much litigation on common law.
And certainly to set the record straight, it's not a particular length of time or anything.
No. And if you check into a motel, not you, Janelle, but I mean, I've had people come and say, well, my husband checked into a motel with this woman, and aren't they common law married, and isn't that bigamous? And the answer is no, it is not, because it takes more. It takes then representing to the world that they are husband and wife.
However, if you are common law married, then what happens if you decide to terminate?
You got to go through all that painful process that we've been talking about. There's no common law divorce.
So you can't just move out.
I have to tell you a funny story, though. One time I gave a talk, people's law talk, in a prison, and I talked to them about common law marriage. And when the talk ended, there was a lineup in front of me of probably 15 people, the inmates, talking about how am I going to get out of what they perceive to be a common law marriage.
I have to interject and say it's rather easy to be married in Idaho under common law. And in state and local government, when I'm addressing this, sometimes there's a line afterwards saying, let us talk about this law in that process.
Now, I want also just to ask one more question. That's about adoption. Under what circumstances do people often use adoption other than with a newborn?
The most adoptions that I see other than newborns are step-parent adoptions. And they're very emotional, too. They really are. And they're not always cut and dried, because in order to adopt a child by the step-parent, there has to be a termination of the natural parent's rights. And the most common case I see of when the mom remarries and the mom, say, has a child living with her, then the new husband wants to adopt. But the dad, the natural father, may not always like the idea. There may be some lingering contact. If the dad has disappeared, then there has to be notice and a hearing given so that the dad's parental rights are terminated. But sometimes it is by agreement, where the step-parent has really assumed the role of the natural parent, and the child calls the parent dad, and the child wants this. And so in those cases, it's a happy ending for all concerned.
I was thinking, too, that the natural parent may have died, and it's a remarriage, and that way it would be easier to do the adoption.
Yes.
I think this is really an important topic. We've had some famous cases in the United States recently about children being adopted, or it appeared they had been, and then after great long court battles, the child is now 2 or 3 years old and is removed from this environment they've known for 2 or 3 years. The first part of my question has to do with what advice do you have to any couple that is about to adopt a child, and neither one of them are the natural parents? How can they make that safe so that they won't face that in 2 or 3 years, both for themselves and the traumatic experience for the child?
I would say, first of all, to kind of reassure our Idaho viewers, in Idaho we have what looks to me like a little bit better safeguard in an adoption. In Idaho, once the natural parent comes to court and terminates parental rights, that is basically considered irrevocable. And we have case law supporting that. And so what that means is, say the birthing mom, the birth mom says, okay, I know I want to place this baby for adoption. And we wait, and we give her time to make sure she's feeling well and there's no medications and she's out of the hospital. Then she comes to court, say in a week or two, some come in a matter of days, and she, before a judge, says, this is my wish, and I wish to have this baby placed, and then the judge in Idaho actually is the witness. Then that is extremely hard to overturn. So I don't feel that we are susceptible to the the type of terrible scenarios that we've seen in other states, because we do have some safeguards, because the system of terminating parental rights by going through the courts is pretty well guarded.
In your work in that area, particularly here in the Northwest, are they a lot of children that are available for adoption, or are they more parents that are wishing, or more couples that are wishing to adopt than there are children available?
My feeling is that there are many more parents wishing and waiting, and yearning for children. And I haven't seen that change really for many, many years. We just don't see the babies available. We get inquiries from out of state too. I know it isn't different out of state.
Another area that I'd like to get into that has to do with family law, and that is where there's abuse by a spouse. In many cases, this is the husband.
To one another?
Yes, to one another. And they've separated, or maybe they've even divorced, and he continues to, through certain psychological, emotional problems that he has, continue to stalk. And I know we have a law against stalking in Idaho, but he continues to come around, and the former wife is just absolutely going through a really traumatic experience, and they do get restraining orders. I've heard a lot of criticism in the United States that restraining orders are oftentimes very ineffective, or that the system doesn't do a very good job in enforcing those. What is your experience about how effective are they in keeping that spouse protected? I mean, we hear a lot of tragedies too in the United States about not being carried out and then the spouse being killed.
You know, the old saying, you hope for the best and you expect the worst. It's one of those things where the restraining order, it's just a piece of paper. That's all it is. It carries the weight of the law, but it's just a piece of paper. And if you have a person so full of anger and hatred that they would do violence to someone they used to love, that the paper may not stop them.
And is the law even when they violate the restraining order, there's not very much time in jail for that, is there?
Well, it will depend. I think that the judges in this county, because there's been so much violence, even one spouse shooting another in a case that was 2 years ago, the courts take it real seriously. And sometimes you don't want to do this, but say if I'm the spouse and my former husband keeps coming around and tormenting me and threatening me and doing things which are violating my privacy, I would consider returning to court for a contempt of court. And
then they go to jail. I'm out of time. We're going to end on that note.
Okay.
But on behalf of Janelle Burke and our staff, Ann Solomon, thank you so much. It's been a pleasure.
You've
been extremely informative,
Thank you for having me.
Okay. Ladies and gentlemen, I hope you've enjoyed this program, and I know that you have. We've been dealing with domestic relations or family law, and I'd like to invite you to be with us again next week for the 5th program in this series entitled Wills, Estates, and Trust. Until then, I hope you have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.